my first slide sets out the key objective, and I'm not proposing to read that, as it really speaks for itself. Attached to this recording is a full transcript of my talk to save you having to take notes. The title of this talk is The Sometimes Broken or Blocked Road. And the title is derived from one of Patrick Leigh Fermore's volumes of diary, oblique autobiography, which recount his interrupted walk from the Hook of Holland to the Black Sea and beyond in the early 1930s. Land rights feature when puzzled landowners or occupiers query the author's presence on their land. The author went on to heroic wartime service in Crete, which he writes about with great modesty. That activity, of course, was governed by other legal principles. This talk will focus on four headings. One, the accepted definition of a servitude. Secondly, the grant and enforcement of a servitude right of access. Thirdly, the acquisition and assertion of a servitude right of access by operation of prescription under Section 3.2 of the 1973 Act. Lastly, I will attempt to make some conclusions. I begin with the first topic, the accepted definition of a servitude in Scots law. The definition in Bell's Principles, the 10th edition, paragraph 979, has stood the test of time. It is in these terms: servitude is a burden on land or houses imposed by agreement, express or implied, in favour of the owner of the other tenement, whereby the owner of the burdened or servient tenement and his heirs and successors to the subjects submits to certain use to be exercised by the owner of the other or dominant tenement, or must suffer some restraint in his use and occupation of his property. Unsurprisingly, the definition was approved of as the classic one by the First Division in Soulsby v. Jones, 2021 SLT 1259 at paragraph 23,